Good evening, everybody. We've had some unexpected filings from Blake Lively. I haven't read them yet, but I'm half expecting it to be some drama or controversy to try and kick the cat litter over the poop that was the audio yesterday. Right, so actually I'll start with this other one first. It's just a quick brief overview. So Blake Lively is applying for sanctions yet again. This is a motion for spoliation sanctions against the defendant. So this is the brief part. Please take notice that for the reasons stated in the accompanying memorandum of law in support of plaintiff Blake Lively's motion for spoliation sanctions and the accompanying declaration of Ezra Hudson dated October 22nd, with the exhibits attached thereto, the undersigned will move this court before Judge Lewis Lyman at the United States Courthouse for the Southern District of New York, and the address on a date and time to be set by the court for an order pursuant to Rule 37E of the Federal Rules of Civil Procedure, issuing spoliation sanctions against all the defendants, basically the Wayfarer defendants, and Jed Wallace and Street, for their failure to preserve electronically stored information. For these reasons and those set forth in more detail in the accompanying memorandum of law, the court should grant Miss Lively's motion in its entirety. Okay, so so basically she's alleging that all of the defendants, the Wayfarers and the Wallaces, have failed to preserve electronically stored information, and this is a cardinal sin, and Judge Lyman, you must issue an order for sanctions for this. Do you know, at this point, I really wish that Wayfarer would get on and do something with Van Zandt. Your Honour, Blake Lively filed a sham lawsuit with nonsense claims against non-existent parties and Jane Does to deceptively obtain data from Stephanie Jones, which she'd already received, and do it in a way that it would deny the rights of the parties. I want to see this motion come. However, I don't think it will anytime soon. So, memorandum of law, there are a lot of attachments. Like we could probably say that this has been overdone, but nearly all of them are sealed, so I can't look at most of them anyway. I will open up what I can. Okay, let's start with this memorandum. No, it's 25 pages. I've had a very quick look through it. A lot of it's redacted as well, so I'll skip over what's not necessary, and we'll get to skip over anything that's redacted anyway. Introduction. It is by now well known that defendants, we know who they all are, texted and emailed each other about their ability to execute an untraceable retaliatory campaign against Blake Lively that would leave no fingerprints. Okay. Their defense from the outset has been that they never moved beyond the scenario planning stage, which was a blueprint intended to bury Miss Lively and her career. Along with their counsel, they have mocked Miss Lively's use of the term untraceable. In fairness, I mocked it too in my letter to the court, because honestly, she uses it that much. I thought she'd taken ownership of it. I completely forgot that it actually came from I think it was Melissa Nathan or Jenny, but it was one of them. So even Judge Lyman, I think, made that mistake too. They have mocked Miss Lively's use of the term untraceable, even though it was first used by defendant Nathan in stressing the importance of leaving no paper trail. Yeah, this is damaged limitation, I think, for the audio. And they've routinely taunted that Miss Lively will not be able to prove that defendants actually implemented the retaliatory campaign, insisting that the sudden onslaught of negative publicity against her beginning in August 2024 was organic, coinciding perfectly with their plans by sheer luck. Meanwhile, defendants have hid the ball at every turn in the discovery process, either failing to produce documents or improperly cloaking them in the attorney-client privilege, forcing no less than 12 discovery-related motions today against defendants and their aligned third parties. Now that the dust has settled and fact discovery and depositions have closed, two things are clear. One, despite defendants' clumsy efforts to cover their tracks, there is substantial evidence that the retaliatory campaign was, in fact, implemented as planned. Oh, I can't wait to see this. And two, defendants flouted this court's orders and destroyed and/or failed to preserve or produce additional material and highly relevant evidence, the absence of which they intend to try to unjustly exploit in their favour. I will say, I'm not going to sort of come straight out of the bat and say, oh, she's talking shit, right? Because if she's got evidence of them doing this, that is quite serious. Miss Lively brings this motion to stop defendants from benefiting from their own misconduct, as described below. From benefiting from their own misconduct. Again, Van Zandt. Honestly, this woman is exasperating. So we can see, already, we're getting into a lot of redactions. First, defendants used ephemeral methods of communication, thereby destroying and/or failing to preserve relevant communications in real time. And just to kind of explain, ephemeral means short-lasting. It's a fancy word for short-lasting. Right, so they used ephemeral methods of communication, thereby destroying and/or failing to preserve communications in real time. So what she's saying is, they use Signal, and you're able to delete stuff, or the messages don't last, and they end up deleted. I don't know the full ins and outs of Signal. I don't use it, but I know there was something about it that made it easy to delete messages, and you could not get them back. And what she's saying here is, well, not only did they plot against me, but they had the audacity to use a messaging app which would make it hard to get the messages. That's what she's saying. Obviously, if Wayfarer choose to communicate through Signal, that is their prerogative. It's not sanctionable. In their deposition, most of the defendants admitted redacted, including as early as July. The evidence further shows that Mr. Wallace redacted at the height of their discussions of a retaliatory campaign. Indeed, this court has already recognised that it is undisputed that the Wayfarers used Signal to discuss topics relevant to this litigation. Quoting the judge. Accordingly, the court previously ordered the Wayfarer defendants to produce their Signal communications, including those of their counsel, by September 8th, 2025. They not only failed to timely produce all responsive communications, but none of the defendants ever produced any Signal communications predating December 20th, 2024. Not one. Can I read the footnote, which has got a lot of redactions? None of the dependents produced a single voice memo from Mr. Wallace at any time prior to December 20th, 2024, including Mr. Wallace. Notably, however, Catherine Case did produce one voice memo from Mr. Wallace dated August 5th, 2024 in her third-party production. Redacted. For his part, Mr. Baldoni claims redacted. So we've got deposition transcript of Justin Baldoni is part of the exhibits that will be sealed. Oh, God. I'm not going to be able to make much sense of all of these redactions, so we just humour me here. I'm doing my best. For the Wallace defendants, the reason for this is clear. They admitted to the court that they did not disable the auto-delete function on Signal. Okay. Oh, this woman's really reaching. They admitted to the court that they did not disable the auto-delete function on Signal, even though Signal was their preferred method of communication for work. The remaining defendants cannot explain their failure to preserve or produce relevant Signal communications or voice memos from Mr. Wallace prior to December 20th, 2024. Do you know it's wild that she's bitching about this when, there is an allegation made that she asked Taylor Swift to delete text messages? Wow. It is clear that the messages are destroyed and cannot be replaced. This fact is all the more damning given that the Wayfarer's lead attorney, Brian Friedman, was a participant on at least some Signal communications with the defendants by August 2024, and yet apparently did nothing to ensure these key communications were preserved. Right. I'm still not seeing that it's his responsibility to make everyone preserve their messages. You can ask. Defendants further contemplated litigation as early as August 2024, although the evidence shows that most of them were clearly aware of the possibility of legal action by November 2023. What? I don't get that. Even she wasn't aware of legal action in November 2023. Yet took no steps whatsoever to preserve their Signal or voice memo communications until December 20th, 2024. Incredibly, Mr. Baldoni testified that, redacted. Second, defendants produced no documents and provided minimal testimony about the work they claimed the Wallace defendants actually performed for their $90,000 fee in 2024, as to which defendants either feigned ignorance or described with one word, monitoring. And she devoted one sentence to Van Zan. No one, however, including Mr. Wallace, has been able to explain what monitoring actually involved. And more importantly, not a single pre-December 20th, 2024 document has been produced either, one, backing up the defendant's claim that all the Wallace defendants did was monitor, or two, reflecting the supposed monitoring work that was performed. In defendant's entire document production, there are no reports, text messages, notes, or email summaries reflecting this alleged social media monitoring work from August 2024. Having retained the Wallace defendants to perform a detailed set of untraceable digital services, paid the Wallace defendants $90,000 over a period of 3 months for those services, and communicated with the Wallace defendants through ephemeral communications intended to eliminate any digital trail, defendants now hope to blame Miss Lively for being hindered in her ability to present the specific direct evidence they destroyed. But as described in more detail below, there is substantial evidence that defendants indeed engaged in the conduct detailed in their scenario planning documents and did exactly what the Wallace defendants and TAG proposed to do, which is entirely consistent with redacted. Given the foregoing, severe sanctions are warranted to prevent defendants from benefiting from their willful misconduct. Ugh, the hypocrisy. To remedy the prejudice caused by the spoliated evidence, Ms. Lively respectfully seeks 1. An adverse inference that defendants intentionally deleted and failed to preserve relevant evidence when they had an obligation to do so, and that the destroyed evidence would have further shown defendants' execution of the digital campaign. I'm just going to explain what she's asking here. She wants the judge to basically make a determination that Wayfarer intentionally deleted and failed to preserve relevant evidence when they had an obligation to do so, and that this evidence that no one can get hold of would have proved that they executed a digital campaign against Blake Lively. She wants the judge to just make that determination. 2. Preclusion sanctions to prevent defendants from arguing that they did not. To prevent them from arguing that they did not execute their digital campaign as they openly planned to do so, or that the Wallace defendants did not actually engage in the digital campaign services they were hired and paid to perform, given the destruction of documentary evidence that would otherwise show that the Wallace defendants actually did. She wants the judge to basically preclude them from arguing that they did not engage in a digital campaign against her. She wants to silence them. And 3, monetary sanctions, at least in the amount of Miss Lively's reasonable attorney's fees and costs for bringing this motion. Good God. I'm speechless at this, actually. Just wow. Well, we'll look at what she has to say. You know, I do want to read it all, but she's asking a lot. She's asking the judge to basically declare that they failed to preserve evidence that they should have, and they knew they had an obligation to do so. Determine that that evidence would have proved that they were operating a digital campaign against her, and then stop them from trying to defend themselves against these allegations of a digital campaign, and just for good measure, award her attorney's fees and costs. I call this opportunistic. However, you know, I'm open to what evidence she brings forth. I just know that I have been in 100% of times Blake Lively is proffered evidence. I have been bitterly disappointed and felt that it was lacking. But here we go. Background. Certain Wayfarer defendants acknowledged receipt of a legal letter on or about November 9th, 2023, triggering an obligation to preserve evidence. Okay, so that was the 17-point document. I don't have it in front of me, so I can't swear to this. I don't remember it saying preserve evidence. It may have, but I don't remember any that being in there. So, and just because it's a legal letter should not automatically then, you don't need, it shouldn't automatically generate an obligation to preserve evidence. She was negotiating like conditions at work, and she got her way. So that should have been the end of that. Okay. On November 9th, 2023, prior to returning to production on the film It Ends With Us, which had been halted between June and October 2023 due to the WGA and SAG-AFTRA strikes, Miss Lively's attorneys sent Wayfarer's attorneys a document entitled Protections for Return to Production. And that is an exhibit, but we have seen it. In the underlying transmittal email, Miss Lively's attorneys explained that the purpose of the protections document was to ensure that Miss Lively and others felt safe returning to the production, and further warned Wayfarer's attorney that if production is unwilling to accept or uphold these protections, our client is prepared to pursue her full legal rights and remedies. Okay. Mr. Baldoni and the Wayfarer dependents who received the document, redacted. There is a footnote, though, which it's redacted. Immediately upon receiving the protections documents, Mr. Baldoni and Mr. Heath wrote to redacted. And there's a deposition transcript of Jen Abel in there too, which is obviously going to be sealed. Text messages dated November 11th, 2023 from Mr. Baldoni to Mr. Heath and Mr. Sarowitz remove any doubt as to their understanding and redacted. Mr. Heath testified that he understood this document, so there's deposition testimony of Jamie Heath too, also going to be sealed. Later, Mr. Heath took active steps to prepare for such litigation, redacted. That same day, June 17th, Mr. Baldoni asked for the recommendation of redacted, to which Miss Abel suggested redacted. Defendants decide to redact against Miss Lively in August 2024. Since at least early August 2024, defendants have engaged in a retaliatory campaign against Miss Lively designed to bury and destroy her career. I thought she had moved the date and claimed that they had always been doing it. Like, for the entire duration of the filming. She keeps moving the date. Okay. Since at least early sorry, noise. Defendants have engaged in a retaliatory campaign against Miss Lively designed to bury and destroy her career. Okay. Among other things, defendants' planned digital efforts have included amplifying or boosting trends or narratives that are favourable to Mr. Baldoni, or to manufacture and perpetuate negative narratives about Miss Lively. Proving that Mr. Baldoni and Mr. Heath's misconduct on the set of the film would become public as the film's August 9th, 2024 release date neared, on or about August 3rd, Wayfarer retained TAG as a crisis PR firm to prepare to discredit Miss Lively in the court of public opinion, should she dare to tell the truth about what happened. Okay, some exhibits to that end. On August 2nd, so is it the day before they were retained? TAG developed a document entitled Scenario Planning. It ends with us plainly already anticipating litigation. No, that's PR. That's how PR works. That does not anticipate litigation. Sorry, I do apologise for some of the background noise. I've got a house full of people. It's evening, and I really can't find anywhere that is quiet. So I have to work with what I've got. As part of this initiative, TAG anticipated working with legal to provide information to ensure Wayfarer and Mr. Baldoni's narrative is properly represented in any and all coverage. In terms of messaging, TAG took aim at Miss Lively directly. One of the key messaging points included highlighting Miss Lively's less than favourable reputation in the industry spans decades and has been reported. See, Blake Lively is herself pointed out that she has a less than favourable reputation in the industry, which spans decades. When Mr. Baldoni expressed concern that this document seemed less aggressive than what TAG had conveyed to him over the phone, Miss Nathan admitted to Miss Abel that the scenario plan document was deliberately written that way because of the danger of recording their true intentions in writing. Okay, so this is where we are now going to misconstrue the text messages. Shortly after her first conversation with Wayfarer, Miss Nathan reached out to the Wallace defendants, TAG's regular collaborators, redacted, and shared details of Miss Lively's protections document on August 5th. Realizing they needed an experienced social media manipulator. Okay. On or about August 7th, due to the uptick in social chatter, TAG recommended retaining, and Wayfarer did retain, the Wallace defendants for a rate of $30,000 a month. And this is just, we've seen all this. This is the email. So we'll go over that again. In his proposal, Ms. Case took care to note that the integral part here is to execute all without fingerprints, demonstrating that the decision to conduct business with no paper trail, including via the use of ephemeral messaging capabilities for digital services, was not an accident, but rather the plan all along. That plan has enabled defendants to hide, in part, how they implemented the digital campaign against Miss Lively. Documents produced during discovery pursuant to court orders ordering Wallace to disclose identities of their clients, however, show that TAG and Wallace defendants are not only capable of implementing the above social manipulation tactics, but that they have done so redacted. These documents include, for example, discussions of redacted. Mr. Wallace requesting client call to redacted. Mr. Wallace expressing the need to redacted. Mr. Wallace saying to client redacted and asking the client redacted. When confronted with these documents at his deposition, Mr. Wallace redacted. Footnote, Wallace's testimony redacted. Oh God, how stupid is this? By no later than August 12th, defendants took the offensive using their own words. It was time to lawyer up, get redacted and redacted. And then there's some more redactions. Even though defendants touted their use of clandestine tactics to avoid leaving any fingerprints, they were not entirely successful and still managed to leave a significant paper trail that evidences their extensive efforts to engage in a retaliatory campaign. For example, consistent with the scenario planning document's key messaging points, defendants were strategic and deliberate in successfully planting seeds of doubt and speculation about Miss Lively's experience on set, amplifying positive narratives about Mr. Baldoni designed to provide a contrast with negative messaging regarding Miss Lively, and amplifying negative stories and content focusing on Miss Lively. Following the early August scenario planning, defendants began communicating through Signal, and as for Mr. Wallace, voice memos, which are the focal point of this motion. Dependents use ephemeral communications as early as August 2024. Consistent with their efforts to run an untraceable campaign with no fingerprints, dependents communicated frequently through Signal, an encrypted messaging platform that features auto-deletion capabilities and voice memos that delete automatically unless saved by the recipient. Redacted. Just days later, on August 10th, Mr. Heath emailed Mr. Wallace to redacted. 2 days later, the tag dependent started a new Signal thread with Wallace, just in case they needed Wallace to connect them with Brian Friedman, because they're very close. We have deposition testimony of Catherine Case, which will be sealed, and in that she acknowledges redacted. Later in this text thread, Miss Nathan instructed Miss Abel to definitely contact Mr. Friedman on Signal. Documents from this same period, August 2024, also confirm that Mr. Wallace communicated redacted, referencing redacted. Oh, she's included an iPhone user guide. And there's a little brackets here, tap keep to save an incoming or outgoing audio message, otherwise the recording is deleted from the conversation. There's a footnote at his deposition, Mr. Wallace testified that redacted. At his deposition, Mr. Heath confirmed redacted and redacted. Both Miss Nathan and Miss Abel admitted to redacted. Oh, this is ridiculous. The same is true for Mr. Wallace, who confirmed that redacted. Party Productions confirmed that redacted. I cannot wait for all of this crap to be unsealed. In addition, after Miss Lively filed her complaint with the California Civil Rights Department and served dependents with cease and desist letters on December 20th, TAG created a new Signal chat, redacted. The very next day, TAG started a new Signal thread with redacted. In a separate text chain that same day, redacted. I'm sure you're all following this, and this all makes complete sense. Even since the filing of this action, dependents have continued to use Signal, and as for Mr. Wallace, voice memos to communicate covertly about their ongoing retaliation against Miss Lively. For example, recently produced Signal communications show that days after Miss Lively commenced this action, dependents and Mr. Friedman were working with content creators to further their pro-Baldonian and anti-Lively campaign. Can we just point out 107 content creators subpoenaed, all except one withdrawn, with nothing turned over, no information shared. This woman is infuriating. On January 3rd, 2025, redacted. 2 days later, on January 5th, redacted. A recording that was not produced. Redacted. On January 7th, Miss Steele posted her carefully curated video from her official TikTok account that covered redacted and has garnered over 1.5 million views. In her video post, Miss Steele slams Miss Lively, accusing her of abusing her power and hurting other women, and claiming that Miss Lively's actions discredit other women that are true victims of sexual harassment. Well, that's fair. I mean, there are at least five motions to quash from content creators, which pretty much say the same thing. So it's not just this Miss Steele. There's a link to the video. Signal communications from February 1st, 2025, which were produced by third party, the Skyline Agency, also show defendants working with Mr. Friedman, his law firm, and Skyline to launch a website that would post communications between Miss Lively and Mr. Baldoni in relation to the ongoing litigation. The handful of signal communications and voice memos that were produced by Skyline during this period demonstrate redacted. Skyline's production not only demonstrates redacted, despite this, not one defendant, including the Wallace defendants, has produced a single voice memo from Mr. Wallace prior to December 20th, 2024. During their implementation of the digital campaign. Defendants admit that they anticipated litigation by August 2024 and redacted. In their verified interrogatory responses, Mr. Baldoni, Heath, Sarowitz, Ms. Nathan, Abel, and Tagg, each redacted. It is clear, however, that they anticipated litigation even before then. Indeed, Wayfarer compiled a timeline of Miss Lively's alleged incidents in June, interviewed Tagg as early as July 25th, after which time Tagg created its August 2nd scenario planning document contemplating working with legal, and shortly thereafter retained street relations. There's deposition transcript from Melissa Nathan as well, and Jed Wallace. All sealed. And redacted. There's a footnote. Because signal communications were not preserved, redacted. Still, not one defendant has produced a single signal communication or, for Mr. Wallace, any voices memo that predate December 20th, 2024. That is because defendants redacted. Miss Nathan claims she began preserving redacted. Footnote, these representations are difficult to accept at face value when third parties produce documents dated after the CRD complaint that were not included in party productions. Mr. Heath admitted redacted. Oh, there's deposition testimony of Steve Sarowitz as well. Mr. Sarowitz confirmed redacted. I wonder if he confirmed that he was going to protect the studios like Israel protects itself from Hamas. We have a footnote. Mr. Heath testified redacted. Despite this admission, no such signal communications have been produced. Mr. Baldoni testified redacted. Wallace discussing redacted. Abel redacted. Oh God. What page? 115. Right. Defendants' obstructive conduct in this litigation confirms that sanctions are appropriate. The facts discussed immediately above were only recently obtained by Miss Lively after overcoming substantial difficult discovery hurdles created by defendants. Footnote, in addition to 5 discovery-related motions with third parties, Miss Lively had to file 7 separate motions to compel defendants' compliance with various discovery obligations. I mean, she's acting like she's not had motions filed against her. There is no such dispute that each of the defendants used Signal as an ephemeral messaging platform to discuss issues related to this litigation. This court has already acknowledged as much. Miss Lively first requested these Signal communications on February 20th, 2025, and the parties thereafter explicitly agreed in the ESI protocol governing discovery to manually review signal communications among any party to the action. Yet for almost 6 months, defendants refused to produce any of them and forced Miss Lively to file repeated motions to compel. In response, the Wallace defendants admitted that because they did not disable Signal's auto-deletion feature, no responsive communications remained in their possession, custody, or control. The court accepted this representation in denying Miss Lively's motion on this score. The court ordered the Wayfarer defendants to produce Signal communications no later than September 8, 2025. And this is it, right? The court has already denied a motion that Lively has filed because basically, the explanation was, well, the text messages were auto-deleted, they don't exist, and we can't produce something that doesn't exist. And the court has already accepted that stance. So I'm curious to see, firstly, Wayfarer's response to this, but see how the judge rules on this. The fact that he's already ruled against Lively is hopeful, but also he gives Lively a lot. The court ordered the Wayfarer defendants to produce Signal communications no later than September 8, 2025. Instead of complying, the defendants made an 11th hour request for a 1-week extension to complete this production, which the court denied for failure to demonstrate good cause. Ignoring the court's order, the Wayfarer defendants engaged in self-help and produced just a handful of Signal communications late. We have a footnote. On September 8th at 11:56 p.m. Eastern. Certain Wayfarer defendants produced some Signal communications totaling only 7 unique messages, which were buried in an 80,000-page document dump and were not even accessible until days later. But they produced them. They produced them on the deadline of September the 8th. It sounds like she's unhappy that they weren't produced how she wanted them to be produced. And then unilaterally, right, so I'll read that again. Ignoring the court's order, the Wayfarer defendants engaged in self-help and produced just a handful of Signal communications late, and then unilaterally continued to produce more at random intervals with no explanation for another month until October 9th. Critically, however, none of the Signal communications predate December 20th. The Wayfarer defendants have established a clear pattern of failing to comply with their discovery obligations and this court's orders, explaining that Lively did not know at that time that the Wayfarer parties would fail to honour the court's orders regarding the timing of discovery. The Wayfarer defendants have also not produced a compliant privilege log for all withheld Signal communications, which will, again, require further motion practice. Furthermore, inexplicably, Mr. Heath, Mr. Wallace, and Miss Abel have not produced any of the Signal communications that were produced by Skyline, documents that were improperly withheld for privilege by Skyline and produced only after an order from this court. Nor have defendants produced any other Signal communications or, for Wallace, any voice memo that predate December 20th, 2024, including in the August through December timeframe, when they were actively discussing, among other things, an offensive strategy to protect Mr. Baldoni and Wayfarer's reputations and to bury Miss Lively. Communication is at the very heart of this case. So far, she's got no evidence of a retaliation campaign. The audio that she thought was going to be a smoking gun bombed, and now she's like, Judge, make them give me evidence against them. That's what it says. Legal standard, I won't go over that. I'll just get to the crux. It's basically they failed to be preserved and they're lost and they cannot be, replaced and, etc., etc. She's arguing also that she has been severely prejudiced by defendants' failure to preserve relevant communications. I'll read that bit actually. The prejudice to Miss Lively is obvious. Among other things, defendants failed to preserve more than 4 months' worth of communications from a platform that it is undisputed that the Wayfarer defendants used to discuss topics relevant to this litigation. This, in turn, has impaired Miss Lively's ability to fully prosecute her claims and to rebut defendants' defences. Particularly defendants' widely publicised claim that the Wallace defendants decided, after being retained, that no proactive digital campaign work was required given organic online sentiment, and redacted. In addition, Miss Lively has suffered economic prejudice based on the time and expense incurred to prove the use and disappearance of defendants' signal messages and voice memos, as evidenced by the many motions to compel that Miss Lively was forced to file. Willful destruction of evidence warrants severe sanctions. And if she can, if the judge agrees, I don't entirely disagree with this. It is serious to willfully destroy evidence. I'm not sure evidence is being willfully destroyed if you have a habit of using an app which has auto delete and, out of habit, you don't turn off the auto delete. Based upon defendant's willful misconduct, intentionally utilising ephemeral messaging, and as to Mr. Wallace, self-deleting voice memos to avoid the production of relevant communications and the prejudice caused to Miss Lively as a result, relief under Rule 37E2 is warranted. An appropriate sanction under Rule 37E should 1. Deter parties from engaging in spoliation. 2. Place the risk of an erroneous judgment on the party who wrongfully created the risk. And 3. Restore the prejudiced party to the same position he would have been in, absent the wrongful destruction of evidence by the opposing party. A court should also consider whether the sanctions it imposes will prevent abuses of the judicial system and promote the efficient administration of justice. Okay. Under Rule 37E2, where a court finds that the party acted with the intent to deprive another of the information's use in the litigation, it may A. presume that the lot information was unfavourable to the party, B. instruct the jury that it may or must presume the information was unfavourable to the party, or C. dismiss the action or enter default judgment. Okay. Because defendants acted culpably in failing to preserve relevant communications, an adverse inference instruction is warranted to remedy the prejudice to Miss Lively in pursuing her claims. When, as here, a spoliating party has acted willfully or in bad faith, a jury can be instructed that certain facts are deemed admitted and must be accepted as true. Accordingly, to remedy the prejudice caused by the spoliated evidence, Miss Lively respectfully seeks the following adverse inference. So this is what she wants the jury to be told. Defendants intentionally deleted and failed to preserve relevant evidence for this litigation. Defendants anticipated litigation with Miss Lively by at least August 2024, but nonetheless elected to use methods of communication that automatically delete, such as Signal, and as to the Wallace defendants' voice memos, to discuss the execution of the digital campaign against Miss Lively, and defendants failed to take affirmative steps to preserve such communications prior to December 20th, 2024. You may presume from defendants' failure to preserve these Signal communications and voice memos that defendants did, in fact, execute the plan that TAG recommended, and for which the Wayfarer parties retained the Wallace defendants, and that defendants intentionally failed to preserve their communications in order to hide this fact. So she wants the judge to instruct the jury to presume that Wayfarer carried out the digital campaign, the retaliation against Blake Lively. Well, I guess it's probably looking likely now that it's the only way she's going to win, because she's got no evidence. Never mind Wayfarer, whether they got evidence to give to her. She brought this action without evidence herself. In addition, the court should issue sanctions precluding defendants from asserting that they did not execute the digital campaign to develop a negative narrative about Miss Lively. Alternatively, Miss Lively should be permitted to present evidence and argument to the jury regarding the lost documents and seek a curative instruction under Rule 37E1, based upon the instruction proposed above, with the exception of the adverse instruction. What evidence is she going to present regarding lost documents? That'd be interesting to find out. With respect to the Wallace defendants, the court should further order an adverse inference that the Wallace defendants possess the requisite knowledge of their co-conspirators in forum actions to support a finding of personal jurisdiction under CPLR 302A1 and A2, and that the Wallace defendants independently understood that their actions would have the requisite consequences in New York under CPLR 302A3. So she's making the jurisdictional argument here. As is well established, evidentiary sanctions may supply the basis for a finding of personal jurisdiction where, as here, the sanctions are consistent with the Hammond-Packin presumption, namely the presumption that the refusal to produce evidence was but an admission of the want of merit in the asserted defence. The requirement of personal jurisdiction may be intentionally waived, or for various reasons a defendant may be stopped from raising the issue, including for discovery misconduct and the Wallace defendants' intentional efforts to cover their tracks in and after August 2024, amply supports such a result here. At a minimum, the court should order a permissive adverse inference and leave the issue for trial. Okay, so she's throwing everything at this now. She's throwing absolutely everything. Judge, can you please tell the jury to believe me before we, just take my word for it. We don't have these messages, but can you tell the jury that they did exist, that Wayfarer deliberately destroyed them? Oh, and by the way, they definitely would have proved that there was a digital campaign against me. And also, can you please also find personal jurisdiction on Wallace? Because I don't want to have to amend my complaint again. That is what's going on here, if I sum this up. In my mind, anyway. It's my opinion. Other people may have different opinions, but this this has come hot off the heels of that audio, which did her absolutely no favours. And it's like, what, her third or fourth, motion for sanctions. She's still got about 2 or 3 sitting, waiting to be reviewed. Finally, dependents should be penalised with monetary sanctions. So this gets one small paragraph. Dependents should be penalised with monetary sanctions and ordered to repay Miss Lively for the reasonable attorney's fees and costs for bringing this motion. For the above reasons, Miss Lively respectfully requests that the judge grant her motion, because he always does, for spoliation sanctions, blah, blah, blah. Okay, so that's the memorandum. I'm going to have a look at what is not sealed. I don't know if there's going to be anything interesting. This is 11 pages. It's a declaration, so she declares she's an attorney. She submits a declaration in support of Lively against the defendants and details of defendants. She also submits this declaration to place before the court certain facts and documents related to Miss Lively's motion. Reminds the judge he granted a portion of Miss Lively's motion seeking to compel Wayfarer to produce their signal communications, which the court ordered be produced no later than September. I feel like we're going to just go over ground we've just covered, right? So she's talking about the September 8th. You ordered them to deliver these signal messages by September the 8th, and they did not do so. Well, they did, but only a little bit. But then they get the rest to me. Yeah, talking about the Wayfarer requesting a 1-week extension, and it was denied. I'm just skimming to see if there's anything relevant we don't know already. Oh, so from there, no, there's nothing. So everything is now, this is a true and correct copy of this, and this. I think, yeah, true and correct copy. Oh, 32. A true and correct copy of text messages dated August 5th, produced by third-party defendants, Jones Works. I really want them to be unsealed because I want to see what they say. August 5th. True and correct. Yeah, so it's all true and correct so far. Yeah, and then rehash the what remedies they want from the judge. Judge, tell the jury this, yeah? Just, go and put in a good word for me. Okay. So that's like the audio and nothing burger. Sorry, I'm now just talking to myself, almost like I say my thoughts out loud sometimes. So this is the email about, what they're going to do, the digital mitigation, remediation type plan thing. I mean, we've seen this before. There's nothing in there that explicitly says, go and smear Lively and her husband and her children and anything else. It's just managed PR pretty much, which is what these companies do. And Blake Lively has companies doing this for her. Not just for this, not just for the end of this drama. Blake Lively and Ryan Reynolds, just as a matter of, course, because of the nature of their career, they have their PR. Obviously, Blake Lively has Leslie Sloan. They will also, from time to time, depending on what happens, will engage with the crisis PR. And it's really disingenuous for Lively to sit there and suggest that she's never done it, she never would do it, and that because Wayfarer have done it, it's absolutely got to be, some kind of retaliation against her. All right, we have some text here. Let's see. Nope, nothing there. Okay, so last one. It says text Melissa Nathan. Oh, okay. Oh, okay. So we have a very interesting image. Creepy. Melissa Nathan, could you send me his email just so I can say thank you for the call, because I feel like it was a bit flippant due to the bug blowing in my hair. She had a bug in her hair. Jen Abel, I'm dead. Jen Abel, are you available? I'm on with Jamie and we need to fill you in on something that's fairly urgent. Melissa Nathan, I'm right mid Nova walk through surrounded by PR. Jen Abel, and Danny is redacted. Melissa Nathan, can I call in 15? Is that okay? Jen Abel, okay, just give us a ring when you're somewhere quiet. Melissa Nathan, I will. Jen Abel, Katie Warren just called me. Lol. Melissa Nathan, OMG. Oh my god. Jen Abel, like, I can't deal with this today. Ha. Melissa Nathan, what the actual fuck? That's the craziest shit I've heard. They clearly have not just read that memorandum or listened to that audio. Can you tell I'm annoyed about the audio? Jen Abel, a statement, lots of question marks and exclamation marks. Melissa Nathan, I've done a lot of stuff and I don't think I've ever heard of something like this before. Jen Abel, ever. Seriously, ever. Okay. So she's referring to a statement. I think this might be the statement that Ryan Reynolds and Blake Lively wanted Wayfarer to put out. I'm looking at the date. 12th of August. Yeah, that's right. That's the date they wanted them to put out that statement taking responsibility. Melissa Nathan, I'm nearly home to write the email, but I'm so confused. Then Melissa Nathan attaches a few, like a news article, Daily Mail, some other stuff. Melissa Nathan, Brian has no conflict. I asked him. Okay, so that's a conflict check to make sure he's not already doing something for like one of the other parties in this, one of the other prospective parties. Ashley doesn't, but she's hesitant as a firm to take on WME if it comes to that, whereas Brian isn't. Okay. Plus, he's representing a lot of women, so plays there in terms of recent clients, all women. Jen Abel, it's so funny. I actually recommended Brian and Steph was the one who shut that down. Oh. So Jen Abel actually recommended Brian Friedman at an earlier point, and Stephanie Jones, by the sounds of it, shut it down. Melissa Nathan, I would say is whatever she shuts down, literally do the opposite. Jen Abel laughed at that statement, basically. Melissa Nathan, Jen, I'm flying to Puerto Rico in a hurricane and the hotel just sent a message they might have to put us in bunkers. Jen Abel, oh my god. Jen Abel, lol, Baloney asked about Baha'i faith. Melissa Nathan, oh boy, what did he say? Jen Abel, just to confirm that Justin's partner with Wayfarer is of the same congregation. Jamie sidestepped it as well. Jen Abel, but interesting. Melissa Nathan, numbers don't lie though. 50 million box office? Melissa Nathan, no matter what. Jen Abel, ooh, confirmation, yay. Jen Abel, Blake and Ryan want Justin to put out a statement. Jen Abel, this is unbelievable. Melissa Nathan, call if you can. Career killer for them and Wayfarer. No, have to fight it. At what point do you fight? It's now. Lawyer up. Now. Jen Abel, this is so crazy. Melissa Nathan, honestly, I've never had anything like it. Can he please hire a lawyer? So at this point, they hadn't hired a lawyer. Even if they were considering it, they had not hired a lawyer. Jen Abel, he needs to. He has one. Oh, he does have one. Oh, But he has a litigator. Right, okay. So Wayfarer had an in-house counsel, I believe, or they have a firm that works for Wayfarer Studios. But he needs a litigator, right? Melissa Nathan, get BF. He's waiting and will also take on WME. Then she sends a tropical storm warning. Melissa Nathan, can I start a signal thread with you, me, and Jed, just in case you need him to connect you to Brian because they're very close, so that you can all have a conversation, because apparently I might be dead soon. Jen Abel, I can reach out to Brian too. We've worked together. And oh my God, what is that? That's where you're going? No way. Okay, so Jen Abel has worked previously with Brian Friedman too. This is not a big surprise though. He's an entertainment lawyer. She's an entertainment PR. You know, and they in the same area. This is not tea for me. Listen, Nathan, I don't know what to do, but yes, lol. Definitely contact him on Signal though. Feel free to add me, obviously, because of the crisis. I really, really strongly want you guys to hire today. There is no way you put out a statement. I don't know what you're answering to still. I cannot believe Blake Lively has included text messages that confirm that these are contemporaneous notes confirming that her and Ryan Reynolds requested that Wayfarer put out that statement that they drafted for them. Jen Abel, we just get them to agree not to do a letter. We are waiting to hear from Justin since he's in Sweden. Can you send me his number and I'll handle by Signal when I get the green light? I can't believe they haven't done this yet. So actually, whereas Blake Lively is submitting this as evidence of they were contemplating litigation, that they should have known, blah, blah, blah. These messages, firstly, they, like I say, they do backfire a bit for Blake Lively because they confirm that, you know, the allegation that Wayfarer were being pressured to put out a statement taking responsibility for everything, and Blake Lively had and or Ryan Reynolds had worded it for them. But also, this just seems to confirm for me that they were really, you know, not rushing to engage with a lawyer for any litigation purposes against Blake Lively. So again, I feel it's like it's something she's put into evidence going, see, this backs up everything. And when you actually look at it in detail, it works against her. And she just keeps doing that. Anyway, so I'm going to leave it there because I need to really think about this, actually. Like, this is a lot to take in. A lot of redactions, too. I will update you when things get unsealed or we get some response from Wayfarer. Thank you for listening and have a great evening.